Good afternoon, friends. Your friend Ashok Arora, practicing in District Court, High Court, and Supreme Court of India. And before you, I am discussing important case law, that is Competition Commission of India, shortly CCI, versus Bharti Airtel. This case is of 2014 and is notable case because it involved allegations of anti-competitive practices and abuse of dominance in the telecom sector, particularly against Bharti Airtel, one of the India's largest telecom operators. Now, first let us dive into background of the case. This case revolves around the unfair practices allegedly adopted by Bharti Airtel in the context of its internet services. The complainant, a company called Telenor India, raised concerns about Airtel's practice of zero rating data services, specifically in relation to Airtel Zero platform. Now, I have used the term zero rating. What is that? Zero rating refers to the practice where an internet service provider offers certain data services for free or at discounted rates without counting the usage toward the data plan. This practice can give preferential treatment to certain apps or services while discriminating against others, which can distort competition in the market. So, friends, the key issues in the case I am going to discuss. The central issue was whether Bharti Airtel Zero plan violated the provisions of Competition Act 2002, particularly its Section 4, which deals with the abuse of dominant position, and its Section 3, which prohibits anti competition agreements. Telenor India argued that Airtel Zero discriminated against competing apps and service providers by providing preferential access to certain apps while excluding others from the benefit of free data. This practice could potentially harm competition in the market by unfairly favoring certain apps over others. Telenor also argued that by offering free data to certain services like apps from specific companies, Bharti Airtel was discriminating against other service providers and harming consumers who were not given equal access to free data. This case also touched upon the concept of net neutrality, net neutrality, which advocates for a free and open internet where all internet traffic is treated equally without discrimination based on content, website, or user. The Airtel Zero plan was perceived as being against the principles of net neutrality by favoring specific apps and services, thereby limiting consumer choices. The Commission of India initiated investigation into the matter on the complaint to examine whether Bharti Airtel zero rating practice violated the provisions of Competition Act, particularly concerning the abuse of a dominant position and anti-competitive agreements. CCI analyzed whether Bharti Airtel held a dominant position in the telecom market and whether its practice in offering Airtel Zero were harmful to the competition. So, after inquiry, in its ruling, CCI found that Bharti Airtel has significant market power in the telecom market, particularly in terms of its customer base and network infrastructure. However, it also observed that the zero rating practice could distort competition and lead to anti competitive outcomes. The CCI found that Airtel's practice had the potential to stifle competition by giving preferential treatment to certain app developers while excluding others. The Commission held that such conduct could harm both competition in the market and consumer choice. However, the CCI did not impose a monetary penalty on Bharti Airtel at that stage, but noted that potentially such practices were potentially harmful to the principles of fair and free and fair competition. Bharti Airtel defended its practices by arguing that it was a commercial arrangement and that it was not aimed at eliminating competition. The company argued that Airtel Zero was a marketing tool aimed at improving consumer choices, not a means of limiting the market. So the CCI's ruling was a significant step in defining the scope of net neutrality in India. While the CCI did not highlighted concerns, sorry, while the CCI did not explicitly rule on the net neutrality issue, its ruling highlighted concerns about discriminatory practices by telecom operators, which could undermine the concept of neutral and open internet. In response to mounting criticism, including from consumer groups and Department of Telecom, Bharti Airtel eventually suspended the Airtel Zero program in 2015, well before the CCI had issued its final ruling. The company stated that it was responding to concerns related to net neutrality and that it would review its business practice accordingly. The case was a significant turning point in the regulation of the telecom sector and issues of competition law. The CCI investigation sent a strong signal to the telecom companies that anti-competitive practices like discriminatory data plans or zero rating could be subject to scrutiny and penalties. This case was part of broader net neutrality debate in India. In 2016, following this and other similar cases, the Telecom Regulatory Authority of India officially issued regulations supporting the principles of net neutrality, which prohibited telephone operators from engaging in zero rating practices that could favor certain service over others. This aligned with the CCI's concern about discriminatory practices. So, friends, this case, CCI versus Bharti Airtel case, is important because it dealt with critical issues of competition law, anti competitive conduct, and net neutrality in the Indian telecom sector. That is short video. Actually, it has gone up to 10 minutes. Please enjoy this video. Sorry for interruptions. That's all.